So this is Mark East with the State Medical Association, and I would like to welcome you all to this May Center presentation on the termination of an employment contract. Presentation is our final program in this series on physician employment issues. Please note, all lines will be placed on mute to prevent background noise. However, I'll open the lines up at different times throughout the presentation so you can ask questions. With that, I'd like to introduce Keith Vogt, who is with the American Medical Association. Keith, Director of Organized Physician Practice Sections at the AMA, where work focuses on the needs of hospital-based physicians and physician multi-specialty integrated group practices. Contribute to a variety of AMA resources for employed physicians, including serving as the editor of the AMA's annotated model physician employment agreements and the AMA's principles for physician employment. Keith is currently heading up the AMA's efforts to develop guidance for physicians seeking to transition from employment to independent practice. He holds a bachelor's degree from the University of Chicago and a master's degree in public health from the University of Illinois at Chicago. And with that, I'm going to turn it over to Keith to lead us through our discussion.
Well, thanks for that introduction. I want to thank the South Dakota State Medical Association for giving the AMA the opportunity to present this information, and I thank all of you for joining us tonight. Here on the slide, sort of the agenda for the evening. As Mark mentioned, we can stop after each of the sections if anyone has any questions. I hope that you'll be able to take away from tonight's presentation is a basic understanding of some of the concepts and terminology related to terminating an employment contract, as well as knowledge of what to expect when you terminate a contract. One mention before we begin, I just want to make it clear that I'm not an attorney. Now, a lot of these issues are not very, legalistic, if you will. I'm not going to get into the weeds on a lot of the legal issues and the nuance. But being said, if you have very specific questions, I'm happy to find someone to answer to you on that. A few words of advice to start. You should really know and understand what's in your employment contract. The contract is central to the relationship between the employer and the employee. And a contract will address all the necessary issues related to terminating the contract and can make for as smooth a termination as possible given the circumstances behind the termination of a contract. The advice I would give is to consult a local attorney with specific expertise in physician contracting before terminating the agreement. And there are three important aspects of that statement. The first is using a local attorney, because a lot of the issues we're going to talk about tonight have differences in different state law, etc. There are some market conditions that a local attorney will know about to help inform his or her guidance to you on the issues. You want specific expertise in physician contracting. You don't want the person who was at your real estate closing, unless it happens to be a physician contracting expert who does that on the side. And you want to consult an attorney before you do anything like terminating an employment agreement, because to start that process, you often cannot go back on it, and it's in motion a whole range of things. You just want to ensure that you understand before you get into it what exactly is going to happen. I'll start with just a little bit of background on the issue of termination of physician contracts. I've seen physician contracts being terminated or not renewed with increasing frequency recently. A lot has to do with employment, physicians increasingly becoming employed. There's what some call the employment mentality, where there's necessarily maybe the same loyalty to an organization as there may have been in the past. A lot with younger physicians, and that's by the fact that there's a 25% aggregate turnover rate in the first years of physicians' employment. In 3 years, 25% of physicians will switch into a different position. Piece of evidence, we see that the turnover for physicians in small practices from the end of the third year alone is 20%. So a lot of physicians who get into that situation say, well, this isn't for me, and they move on from there. You can see a graph there on the slide. It has physician turnover rates. Those are the overall rates. So what portion of all physicians change jobs from any given, within a given year? And I don't have a graph that reflects this, but by some estimates, the current rate is as high as 7% or more. Other factors related or that contribute to this turnover rate. There's no baby boomer retirements increasing. There are economic conditions. Physicians are less likely to retire when the economy is bad, and as the economy gets better, they're more likely to retire. So issues like that in hand too. One thing clear is that these figures can actually appear alarming to employed physicians because they're thinking, oh my God, look at all these physicians who are, they're just biting the bullet and they're disappearing. But rest of it, these are not firings. These are not physicians typically being, fired at a hospital or let go for some other reason. By and large, these are physicians who choose to move on to new positions. And here I can give you that sort of bears that out. Is if you look at the cost to the employer of turnover, average, it costs $30,000 to hire a physician, and the cost of a vacancy in a position for a hospital is $46,000 per physician per day in lost operating revenue. So it's very significant, and you can understand that employers really do not want physician turnover. We talk about the aspect of the termination event, which is what triggered it, and then what are the ensuing processes. I'm going to start with 4 common contract termination scenarios. And the start with these is because the way that the reason the contract is terminated has a lot of bearing on what happens next. These scenarios will not apply universally because not all contracts include cause provisions, and I'll get into what without cause and for cause mean. But these are the ways that a contract can end. So the employer can terminate a contract without cause. An example of that would be the employer says, well, I can't afford to keep you on anymore, so sorry, I'm terminating the contract. The employer will terminate a contract for cause. Maybe violated some provision of the contract. Maybe you didn't show up for a few shifts or something like that. Now, the employee can also terminate the contract without cause. Maybe you're going into private practice, or maybe you have a spouse who got a job in a different state and you're moving, something like that. The physician can also terminate the contract for cause. So that would be if the employer has not upheld his end of the obligations. So example there would be you get hired by a group practice and the contract states that within 3 years you'll be offered a partnership, and that just doesn't happen. At that point, you can up and say, well, I'm terminating this contract for cause because you had that obligation. Now, there are some other less common situations. I'm not going to detail on these, I'll just mention them. One, automatic termination, and there's actually some overlap there with for cause termination, but these are triggers where if it happens, it automatically terminates the contract. And a good example would be the physician loses his or her license. Contract automatically terminated. Disability termination, so if a physician becomes disabled and can no longer work, there could be a provision in the contract that would automatically cancel the contract. And then termination for illegality. So if there's an aspect of the employment contract that's illegal under the state's contract laws, the contract can be considered terminated and null and void. Now, that usually doesn't happen because what will usually happen is the parties will agree that they'll work together, or the court will mediate some settlement where they'll cut out the parts that are illegal and they'll leave the rest. But this is how contracts can be terminated, and as I said, it really matters for what happens next. The reason it was terminated. A discussion about termination without cause. It sounds like the party can terminate the contract for no reason and don't have to state a cause. It's the least complicated form of termination. You see there a sample without cause termination provision. It's 2 sentences, and really the second sentence is not even necessary for the actual without cause portion of it. It's a two-way street, so both the employer and the employee have the right to terminate the contract in that way. And then we use for newer employees. You can use a probationary period where the employer has the luxury to just let anyone go for any reason without really having to go through the hassle. Without cause usually requires a notice period of between 30 and 90 days. And sort of a side note there is that, if you have a contract that includes a termination without cause provision, say a 3-year contract, you don't have 3-year contract. What you have is a 30-day contract that renews every day for 2 years and 11 months. Something to keep in mind when you're thinking about a contract that has termination without cause in it, if you're looking for security. Now, without termination, the party has to state a cause for the termination. And so really no due process or hearing rights available because frankly, there's nothing to argue about. Now, that being said, there often is, in fact, cause for the termination, even if it's not stated. And what that cause is, it can lead to some very problematic uses of without cause termination. Two broad examples here. So termination for illegal reasons, discriminatory reasons. And an example would be a pregnant woman's contract is terminated without cause when the unspoken reason was the employer didn't want to deal with maternity leave and what that entails. Really an illegal discrimination against a protected class, and employer cannot hide behind without cause termination. That could be very difficult for that physician to prove that was in fact the motivation for the termination. But despite not having process within the contract itself, it would have some legal remedy in the courts for that illegal act. Now, inappropriate use of without cause termination. It happens when termination without cause is used, when there is a cause, and that cause is related to quality or safety. And there are 2 reasons that this kind of use of termination without cause is problematic. It's really unfair to the physician. He is accused, essentially, of being a physician and has no chance to refute those accusations. And then the employer says, well, we're just going to terminate you without cause, the end, and that's the end of it. The second that's problematic is more issue for the profession. So the medical profession is a self-regulating profession where physicians have an ethical responsibility to sort of monitor themselves and others and ensure that there are not bad physicians out there practicing. Look at when you have, for example, a hospital, that means that a physician is not performing highest quality or at the high level and providing subpar quality care. Well, we don't want to go through the hassle of fighting someone for cause or going through the medical staff, so we're just going to let this physician go without cause and we're in the hands of it. Because now you have a physician out there who really is not a good physician and knows it, and that position could essentially hurt someone eventually. So that's a second reason that without cause termination can be very, very problematic. Termination for cause. I can really list a variety of reasons under which the contract may be terminated for cause. Reasons are very specific. So, for example, as I mentioned, the physician's license, practice medicine can expire or be revoked. Physician could be excluded from Medicare or Medicaid. Could be, impaired using or illegal substances, something like that. But there are reasons that it can be very broad and somewhat fuzzy. For example, failure to perform a duty under the employment agreement, and that's a catch-all for you did something in the contract. So see here on the slide, this comes from the AMA Annotated Model Physician Group Practice Employment Agreement. It's a very physician-friendly list, and let me explain why. If you look at the bullet point, you'll see the only place where quality is even invoked at all. And the employer can fire you if he or she deems you're not meeting the highest quality requirements or something like that. It's located through the medical staff. So the physician-friendly way to ensure that if it's going to be terminated for cause for a quality reason, that it's the right people deciding that it's actually a quality reason. Medical staff issue a little bit further in a bit. Now, the list causes for which the employee is entitled to terminate the agreement. Usually fewer in number in the list of reasons that the employee can terminate the agreement, but it still does include the broad catch-all of the failure to perform a duty under the agreement. One of the classic sort of employee-initiated termination scenarios you'll see is for the hospital loses its Joint Commission accreditation, and that means automatically all the employees can decide that they want to terminate the contract for cause and move on. Termination without cause, there's typically no opportunity for due process. But what about for cause termination? And so the key question is, assuming the contract does provide for due process, and not all contracts do, who conducts that process, and with a very ideological discussion, and then we can get into some of the applications in actual contracting. My position on this issue is that in cases of for-cause termination, physicians should, in fact, be afforded due process. And if it's a issue or some other issue where the medical staff would have some say in it, it should be the medical staff process as opposed to an HR process. Now, a clinical issue like not showing up for work or something like that, then the physician should be afforded the due process outlined in the employer's human resources policies and procedures. As I noted, there may or may not be any listed there. And there are two reasons for medical staff involvement in the quality piece. And I mentioned already when I talked about problematic issues without cause termination. Those to repeat are 1, fairness to the physician, and 2, ensure that the profession can identify physicians who have problems with quality. So when we process, what exactly do we mean? Certainly a concept that's related to medical staff peer review, and the specifics come largely from the Healthcare Quality Improvement Act, which provides medical staff immunity against damage claims by individual physicians who are harmed by disciplinary actions taken by the medical staff. So physicians brought up on charges before the medical staff, and the medical staff decides, yes, this is indeed a problem, and we're going to terminate your medical staff membership and privileges. That physician can't turn around and sue the medical staff either as individuals or as a collective for damages related to losing those privileges, provided that the physician was afforded full due process. And so that due process for these long lists of what entails due process come from. 2 slides, you'll see how the AMA defines the components of due process. I won't go all of them, but basically in a nutshell, it's talking about a fair trial, getting a fair shake and an opportunity to rebut things. And include, you need to have a statement writing about what exactly you're being charged with. You need to know what the evidence is against you. You should have an attorney present. You should have an opportunity to make a defense, to cross-examine witnesses, those kinds of things. And most importantly, the burden of proof is on the employer to show why you should be terminated. That's good, but in reality, this language can be a very difficult point of negotiation. And especially in states where employment is at will, the physicians expect that an employer will really object to this kind of language. And when I say will, that simply means that the law allows an employer and employee at any time for any reason unless there's a contract that says otherwise or a discriminatory reason. As I discussed before, you, of course, cannot fire someone for those reasons for an employment contract. You would hope the best case scenario is that get all that due process language added to the contract. But what you would hope for is that the contract will defer to the medical staff. Sometimes there's a question of quality. Issue will be adjudicated by the medical staff, and no final action will be taken on the termination until the medical staff has made a determination as to the charges. And we would hope that if the medical staff clears the physician of wrongdoing, then the termination will be called off, but unfortunately that's not always guaranteed. It's about termination triggers or any of these processes.
Just 1 second. I'm going to go ahead and I'm going to hold up or unmute all the phones. So I apologize, Keith. It's going to take me just 1 second here. Okay, at this point in time, all phone lines have been unmuted for those that have called in, so they're open so you may ask questions. For those that may be just listening on the computer, you can type those in, or you can also dial in and we'll be able to address those for you. Okay, one more time, putting out there any calls, any questions for Keith at this time.
Okay, if there's any questions towards about this topic, we can certainly circle back. Your contract has been terminated, with the cause or lack thereof having been firmly established. What happens now? And one thing I want to point out is that it's important to note that simply ending the contract does not really end all obligations between the employer and the employee. So the contract is done, you're no longer working there, but you may in fact have things that are left to do. And with the obligations of the employer. So of course there are financial obligations, and those in large part on the payment methodologies in place should be clearly outlined in the contract. About physician compensation, there are basically different areas of that. One is guaranteed salary payment. So that's, if the agreement is that you get paid $10,000 a month, that's pretty straightforward. You're just going to get a pro rata amount on that. Another issue to look at is benefits. On vacation time, the contract may stipulate that, you get paid out a certain percentage of your unused vacation time or some combination. And then the third aspect is formulaic compensation payments. And this gets really interesting and really complicated very quickly. So about formulaic compensation, what we're talking about is compensation that's usually determined after the fact. So you may have volume-based payment where, based on how many work RVUs you do, you get paid a set amount. Of course, that's going to be known immediately in advance. You could also have things like, what are collections? How much money was collected based on procedures that you performed? And so the accountings for these issues are not always done immediately. They're sometimes done quarterly or even yearly. But the physician, of course, still needs to be paid in the interim. So the physician is usually paid estimated compensation, which are called draws. And at the accounting period, whatever it might be, a quarter or a year or whatever, the physician, or the hospital may find that the physician has been underpaid or overpaid and have to compensate accordingly. And so it makes it very complicated when you terminate a contract on short notice, because now you have all these issues to sort out. One other one that I would mention, this of portions of accounts receivable, is especially problematic when you have payment that's based on collections. You may get some percentage of the collections. If you terminate the contract in the month of June and the person hasn't collected all the money yet for the month of May, you provided services in that month, you're entitled to some of that, account receivable. But how do you determine what portion of it? How do you determine, collection fees, all those kinds of things? So it's very difficult, very complicated. And I point out that the employment contract should be crystal clear in how the final settlement payment is determined, and it should include even examples of calculations just to make it 100% clear exactly who's owed what and when. One financial obligation you may see in the termination of an employment contract is severance pay. A lot of employment contracts include some severance pay. General rule of thumb for severance pay is that the employer will receive it only if the employer is the cause of the contract termination. So that means you as the employee could not have done anything to stop the termination of the contract. So the two ways you could do that: one, if the employer terminates your contract without cause, clearly you had no effect on that. Or secondly, if you as the employee have to terminate the contract for cause because the employer did not uphold some obligation, that's not your fault, and you generally be entitled to severance pay if that's included in the contract. Two other contract obligations for the employer. One is retaining and making available medical records. We'll get to that a little bit later. And the second one potentially is patient notification. So your employment contract may state that upon the contract, the employer has the duty to notify all of the employee's patients that the employee has moved on and give the employee information about where the physician is going to be. The patient notification issue a little bit later as well. So what are those contract obligations for the employee? First one you'll see in employment contracts is an obligation to complete various tasks. For example, you have to complete your medical records and billing statements. You may be asked to assist in collections. You have to return equipment, any confidential information you have in your as well as medical records. Depending on the state, the employer can actually hold these things over the employee's head and withhold the final payment until the physician has satisfactorily completed all of these tasks. I also have financial obligations. I spoke a little bit earlier about draws, and if you have an excess draw, you're going to have to pay that back. Unvested benefits you may have to pay back. For example, if you're part of a group practice that says, well, we'll pay 20% of your student loans every year for 5 years, but you stay with the group for 5 years. You know, after 3 years, they may have paid 60% of your student loans, and now the contract terminates. You didn't go a full 5 years, so they may demand to have all of that back, or the contract may say you have to pay half of it back. But just be aware that you may have some financial obligation around unvested benefits. A couple of other areas where you may have financial obligations. Direct expenses is one. So if the employer pays for you, maybe the employer gives you $2,000 a year for special or professional society memberships, and you spend $2,000 of that in the month of January, and then you quit in the month of June. The employer come back and say, well, that really was prorated, and if you stay only 6 months out of the year, you only get half of that. So you really only had $1,000, and you need to pay us the other $1,000 you already spent. Costs, I mentioned that with respect to accounts receivable. So if there are outstanding accounts receivable and you expect to get some portion of that, you can also expect that whatever portion of that you get is going to be reduced by some portion of the collection costs to get that money. And refund liability. So suppose there's an overpayment from or 6 months after you leave the practice, there's a RAC audit, and Medicare comes back and says that the practice owes them $100,000, and your billing was responsible for 10% of that. You could have a refund liability to your employer for $10,000, and this will be outlined in your contract. Post contract obligation I'll mention for employees has to do with confidentiality, non-disclosure, and non-disparagement. So confidentiality, of course, patient information remains confidential even after you leave the practice. Non-disclosure, you can't be giving away the trade secrets, the information about the practice to other parties. And non-disparagement, that'll typically say that you cannot be going around saying bad things about the practice. Non-disparagement is usually a two-way street. Hope contract would say that, yes, you cannot say anything bad about the employer, but by the same token, the employer cannot say anything bad about you. Contract obligation I'll talk about is tail coverage. Tail coverage, you first need to understand the difference between occurrence coverage and claims-made coverage. So occurrence coverage covers you for events that occur during the policy period regardless of when the claim is made. I have an occurrence coverage that lasts for 1 year, and anything you treat during that year that sues you, you're covered. Claim coverage, on the other hand, covers you only for events that, 1, occurred during the policy period, and 2, for which a claim is made while the policy is still active. So if you've made coverage for 5 years, and you cancel it after 5 years, and you have a patient who you treated in the 3rd year, and then in the 6th year, the patient turns around and sues you, you know coverage because your claims-made coverage policy is no longer active. And so cover yourself when the claims-made coverage policy is canceled is with tail coverage. Typically, that covers you for the remainder of your career for anything that's not covered by the claims-made coverage. Tail cover is typically required by the employment contract, and it's going to be quite high. So it's usually 200% or more of what's called the mature premium. So the way that claims-made coverage works is that it's out with a relatively low premium in the first year, and it increases for 5 years typically. After 5 years, it usually goes up by some amount indexed to inflation. And so that's called the mature premium in the year. And basically, you'll be charged double that for your tail coverage. Now, it can be a huge chunk of money, you know, $100,000 or more, depending on the specialty. And I remember some reports from ACOG that obstetricians are paying $150,000 or even more for tail coverage. Now, the cost can be split between the employer and the employee in a variety of ways. Typically, what you'll see in a contract is that the employer is responsible for the cost of claims-made coverage premiums while you're actually employed, so during the term of employment, but then the physician is obligated to pay for the tail coverage alone. Tail coverage. Well, you could try to get it included in your employment agreement that your current employer will pay for the tail coverage upon termination of the agreement. You may not be successful there. Your better bet might be trying to get them to pay half of it or a quarter of it or some lesser amount. But you can certainly try that. In your option, of course, you can just go out and purchase it. If you're moving to a new employer, you can try to get the new employer to pay for it through the insurance policy at that place. And that's what we call nose coverage. And even if the new employer won't flat out pay for nose coverage, they'll often front you the money for it. So, you know, you can't pay $150,000, you know, when you move the new employee and to the new employer. Then they say, we'll give you the money and you can pay us back over a period of 3 years. We'll just deduct it from your paycheck. And something important on tail coverage that I want to mention is you should never leave a gap in coverage, even if you're seeing patients during that time. It can happen when you have claims-made coverage. You know, suppose you leave the employer, your current employer, and you start with a new employer 1 month later. During the month, you do not have any kind of coverage whatsoever. If you have your patients from your previous employer who sue you during that one period, you're going to be 100% liable for those costs if you do not have tail coverage in place. Third, on the post-contract obligations.
Okay, just 1 second. I'm going to go ahead and mute all phone lines. Okay, time all phone lines have been unmuted. If anybody has questions for Keith, please proceed and ask.
Okay.
So, would all offer any questions for Keith at this time? Okay, go ahead and hearing none, I'm going to go ahead and mute all lines again so you can proceed.
Okay. Now we talked about termination of the contract and what that entails and what the processes are. We've talked about remaining obligations. The next sort of logical thing to consider is what are the effects of that termination on your future practice? A discussion about restrictive covenants. And most of us, when we think about restrictive covenants, our minds immediately jump to geographic and temporal restrictions on practice, which are typically called non-compete provisions. So, for example, you know, your employer and the contract says you may not practice medicine within 10 miles of this office location for the next 2 years. But restrictive covenants are typically a lot broader than that, and they can encompass a variety of restrictions on practice. So I'm going to start by talking about restrictive covenants in general, and then I'll move on to some of the specific examples of what you might find included in a restrictive covenant. First note about restrictive covenants is that there are ethical implications. Restraint on what a physician can do, and unreasonably restrict the right of a physician to practice medicine. That can be problematic. If they don't make reasonable accommodation for a patient's choice of physician, you know, that's also ethically problematic. With that being said, there are good arguments for and against restrictive covenants. Now, from the perspective of the employer, they're going to want to protect the investment in a physician. And so what restrictive covenant really does is it gives the employing medical group or hospital the freedom and security to invest significant resources in a new physician, with the employer having to worry about the physician up and leaving before the employer has an opportunity to recoup on that investment. For that reason, restrictive covenants are generally especially applicable to physicians right out of residency, where they really don't have all of those skills. They're not bringing with them a patient base. They're learning and getting a lot from the employing group. It also protects the employee group's patient base. So if they have their patients, they have people who recognize the name of the practice. They're not necessarily going there just because of Dr. So-and-so, if they happen to love Dr. So-and-so. The employing group will recognize those patients as theirs, not necessarily those of the individual physician, and they'll want to protect that patient base. And then employers are going to try to protect proprietary business information. And this is really more applicable to a physician who has held a leadership, management, or other key role in practice. And from the perspective of the employer, they don't want someone out there competing with them who has been privy to all their secrets. So someone who knows what their business plan is, what their expansion plans are, what their marginal cost of patient acquisition are. They don't be competing against someone who knows all their secrets. So that's really from on that. Now, for the employee, there's also a case to be made about why restrictive covenants should not be there. Of course, there's interference with the patient-physician relationship. A lot of patients couldn't care who their physician works for. They're attached to that physician, and they do with that physician. Physicians rightfully point out that arguments that employers make for restrictive covenants often overstate the employer's investment in the physician. So yeah, it's true that if you have a brand new physician, the employer may actually be investing a lot of resources in that physician. But if an established physician, someone who's been around 10, 20 years, the physician may in fact bring more to the practice than the actually gives to that physician. And so maybe an overstatement of that investment. From the physician's perspective, this disruptiveness of leaving one employer and now suddenly having all these restrictions on your practice, your house, pick up your family, and move to a different town simply because you canceled an employment contract. Very disruptive. So moving on about speaking on restrictive covenants in general, there's an argument about whether they're enforceable. And I'll just very generally that we know restrictive covenants are in fact a restraint of trade. And for that reason, they're viewed very skeptically by courts. And when any ambiguities or gray areas, the restrictive covenants will typically be construed against the employer, and that is in favor of the employee. Statutes and case law vary from state to state. Some states, like Massachusetts, are legal to enforce a non-compete provision against a physician. There are states where there's no specific mention of physicians at all in the law. It's completely silent. And then there are some states where there are varying forms of regulation about what a restrictive covenant for a physician can or cannot include. In states where there's not an outright prohibition, you have to weigh a variety of factors to determine whether a restrictive covenant is in fact reasonable and enforceable. It's a bunch of things. They'll look at, are there legitimate business interests at stake? So the employer will say, well, we don't lose our patient base. And the courts decide, is that the actual reason, or do they just not want competition? And especially when you talk about non-compete provisions, they have to look at the scope and at reasonable given market conditions. So reasonableness in one location might be very different from reasonableness in another. So if you look at rural Montana, where there are not very many physicians and hospitals, it's perfectly reasonable to have a restrictive covenant that says you cannot compete within a radius of 25 miles. Whereas look at New York City, that would be absolutely ludicrous because that would eliminate so much competition. So again, is the scope reasonable given the market conditions? Reasonable restraint on the physician's trade. Does it create an undue hardship for the physician? The courts will look at public interest. So is there a physician shortage in the area? If there's a physician shortage, they're much more likely to look at it and a restrictive covenant very skeptically. And then who and what triggered the contract termination. So a general thumb here is that if you as the employee could not have prevented the termination, a restrictive covenant will generally not be enforceable against you. So if the employer terminated the contract without cause, usually that means that the restrictive covenant will not be enforced. Or you as the employee terminated the agreement for cause because the employee failed on some obligation, and typically the restrictive covenant cannot be enforced against you. A final issue that the courts will look at is whether there's a buyout option. And often an agreement will contain buyout provision that allows the physician to pay a fee or liquidated damages in lieu of the employer enforcing the non-compete agreement. I think it's just one state, Texas. The law actually says if you're going to enforce a restrictive covenant, there must be an option for the physician to buy his or her way out of it. So I'm going to do some specific discussion of aspects of restrictive covenants. The first cat is non-compete provisions. One is the one that I think most people are probably already familiar with, basically saying that the physician is prohibited from practicing medicine in some defined geographic area for a specific period of time. And of these provisions, they can be very onerous on the physician. And the language that's included in the PowerPoint presentation here, see this language about, physician shall not own, manage, operate, control, or participate in any manner of ownership, management, operation, or control, or serve as a partner, principal, agent, consultant, or otherwise, or any financial interest, and it goes on and on and on and on. Basically, airtight, you cannot compete against that employer. The next of restrictive covenants I want to mention is patient solicitation. So when we say solicitation, and sometimes this is also called rating, what is purpose contact with patients, try to convince them to leave the employer and come to the new physician's office, the physician's new office. And the contract will say you cannot solicit these patients. If you look at the language here, I'm going to point out that this is actually a very employer-friendly non-solicitation clause. True for two reasons. You'll see that it says you're not permitted to solicit any patients of the employer. So that's not necessarily just the physician's patients, it's any patient of that employer. So that's very broad. If you work for a medical group that's dominant in an area that has some huge portion of the market, now you try to go out and you have a non-solicitation clause that says you cannot solicit any of those people, you could be in some serious trouble in terms of viability of your new practice. The second thing I would point out about that language that's very friendly to the physician-employee, there's no exception for general advertising or promotion. It cannot directly or indirectly solicitation. And, if you got an ad in the newspaper advertising your new practice, that could be viewed as indirect solicitation of those patients, and it could be deemed to put in violation of that restrictive covenant. That contract language and what I just discussed, we have to recognize that when you terminate the contract, that does not end the patient-physician relationship. Policy holds that the physician and or the employer should notify that physician's patients that physician is leaving and give information about how to contact that physician, in the event that the patient decides, yes, I want to move along with that physician. Something else important to note is that if you have a covenant preventing a physician from treating former patients, that's typically not going to be enforceable. So yes, you cannot solicit them, but if that patient decides, I want to move with physician to his new practice, we will enforce a restrictive covenant that says you cannot treat those people who willingly come to you. How does this notion of patient solicitation and notification play out in reality? What you'll see in an employment contract is a provision that says, yes, we notify patients about the employee's departure, but we will do it in such and such way, and it will go into very specific detail, and I've been included here, but this sample provision actually includes a template letter that outlines exactly how those patients are to be addressed in notifying them that the physician is leaving the practice. Very advisable for parties to agree to the form of the notification in advance. That's a lot of problems when the time for termination comes. Now, that's not necessarily related to risk covenants, but is related to and keeping your patients with you, is access to medical records. So medical records for patients treated by a physician employee are typically deemed to be the property of the employer, not the employee. So as I noted, one of the obligations of an employee upon termination is returning all of those medical records. But physicians should be given access to these records for legitimate purposes, and that's typically included explicitly in the employment agreement. So for example, if a patient is moving along with the physician to the new practice, the physician is entitled to a copy of those records. If you have things like malpractice actions against the physician, or there's an administrative investigation, a RAC audit or something like that against the physician, or if the physician needs to compare records, to have his treatment of current patients, those are all permissible reasons for the to get access to those records. One piece of restricted covenants that I'll talk about is solicitation of other employees from the practice or the hospital. Typically, these clauses restrict the physicians leaving from offering employment to current employees of the hospital or group. So you can't tell all of your nurses, well, I'm leaving, do you want to come work for me? These kinds of restrictive covenants are much more enforceable than the geographic or temporal restrictions. You'll see here some sample contract language. One I would note that's not in this language that the physician want to try to do is include an exception for any employees that the physician brought with him or her to the practice or hospital. So in an independent practice and the hospital acquired your practice and they acquired all your staff along with it, and years later you decide, well, this really isn't working for me, I'm going back into independent practice. You would want to have an exception in your contract that says you may take your staff back with you. This language that's here could be worse. There are some contracts that contain language that's so unfriendly to the physician that it will go so far as explicitly prohibiting the employee from even employing another individual, even if the physician did not solicit or induce that individual. So, one thing to say you cannot offer employment, you cannot, solicit, you can't call up and say, hey, want to come work for me? It's another thing to say, well, even if that person comes to you of their own volition, you cannot hire them. Keep in mind when you look at these kinds of clauses. A little bit to an issue that can sometimes be considered part of a restrictive covenant, but not necessarily. I'm going to start with sort of a very pure ideological position that the AMA has outlined, and we can take it from there. The AMA generally opposes linkage of employment contracts and medical staff privileges. So on the side, I think it's perfectly why. Basically you cannot have privileges just because you've been hired. Privileges are granted on the recommendation of the medical staff to the governing body only. Contracts already recognize this fact, and there's language generally about the contract being dependent on the physician's ability to secure necessary privileges. But this is not necessarily accepted. So on the hiring side, a physician is fired. Should that physician lose his or her privileges automatically? And things are a little bit up in the air in reality. So the AMA's position is that if you never be able to resign privileges, unless there's an independent action of the medical staff and the physician has been given full due process. I shouldn't say never, there's one exception, and that exception relates to exclusive contracts. situations in which it would be unreasonable for a physician to expect to retain privileges upon termination of the contract. So if you have an exclusive contract to provide some service in the hospital, they want to get another physician to provide those services. It makes sense for you to be remaining on staff with those privileges when they want to give the exclusive right to those privileges to a physician. AMA recognizes that that's not always possible to decouple medical privileges and employment. Outlines sort of a narrow situation in which that is permissible. And there are three parts to it. One, the agreement should be for the provision of services on an exclusive basis. The termination of the contract, the medical staff has to have a say in whether that's appropriate for patient care. The third piece is that the agreement should explicitly state that that's a consequence of the termination of the contract. It must explicitly say, if this contract is terminated, you must give up your privileges. Something that it's not really in the contract, and then you get terminated, and now the hospital says, now you're going to give up your privileges, even though it wasn't in the contract. So the pure ideological position. Let's take a look at how it actually works in reality. So, only for hospital employees, it's not all uncommon for a contract to say that membership and privileges have to be resigned upon termination of the contract. That's especially true in cases of exclusive contracts and when you have closed departments. But it can be true just more generally that you know the contract ends and the hospital doesn't want you around anymore. It can actually provide some protection for the physician employee. There's no language there, but basically it says that the physician retains full medical staff membership and privileges upon termination of the agreement, unless an action of the medical staff occurs after full due process has been afforded to the physician. Employees, medical staff bylaws can also provide some protection. So even if you can't get that particular clause that I just mentioned added into your contract, if bylaws say something to the effect of bids and et cetera are not subject to waiver by employment contract, help you in your case losing your privileges upon termination of the contract. Again, this is for when we're talking about termination for reasons related to quality. If there's termination for other reasons, the medical staff generally will not become involved. And they're saying, well, I'm glad I'm not a hospital employee because, at least I work for a medical group, and, if that relationship goes south, I've got my hospital privileges and I can restart a practice somewhere with that as the basis. But that's not necessarily true. And there are two reasons that you as a medical group employee can lose your privileges when the contract terminates. The first is if the group holds a service line or co-management agreement with the hospital, or an anesthesiologist in a 20-physician practice, and you provide anesthesiology services in 2 hospitals on an exclusive basis. That group's contract with the hospital will typically say, if a patient leaves your group, he or she will automatically lose their privileges, and that will be in your individual contract. And even that, you can have a contract that simply says that you will resign your hospital privileges. And some sample contract language here. This example where I could very well find that that's an undue hardship on a physician. So say you work for a small group, maybe 5 physicians. You all provide services in 3 community hospitals. Those are the only hospitals in the area. In group, there's a restrictive covenant that says you're going to give up your privileges. Not practice anywhere because you don't have privileges at any of the 3 area hospitals anymore, and you're going to have to move on. So that would very well be considered an undue hardship on the physician. So restrictive covenants and negotiating what should be in the contract from the outset. It's important to understand where each side is coming from. I've sort of outlined some guides of what side might be thinking about. So what the employer trying to do? Well, the employer, of course, wants to have geographic and temporal restrictions. They're going to want to supplement that non-compete with other restrictive covenants, such as not soliciting existing employees. We're going to try to get you to resign from hospital medical staffs. They're going to probably try to get something in there in your contract that says, please agree this covenant is reasonable. Something like that in your contract, it becomes difficult to argue in court that, well, this is an unreasonable agreement, because the judge will say, well, you signed a contract that said you thought it was reasonable, so now how can you argue that it's unreasonable? Of course, you'll also try to have the employment agreement be subject to what's called blue penciling. So basically, if the judge finds that some portion of the restrictive covenant is unenforceable, the judge will have the option to rewrite the restrictive covenant in a way that's less unreasonable and then enforce it in that manner. Now, perspective of the employee, of course, you want to try to seek elimination of all restrictions on practice activity following termination of the contract. Of course, that's not possible. The next step is at least negotiate a reduction in the geographic and temporal scope or any other kinds of restrictions you can get limited. Get excluded for special circumstances, like seen in a specific hospital. Recommend that that's sort of your backup if you want to start your own practice in the future. I mentioned a little bit earlier this notion of non-solicitation and the effect that general advertisements can have on that. So you definitely want to get an exception in there that you can engage in general advertising and that will not be considered solicitation of the patient. Of pieces of guidance for how do you actually deal with a restrictive covenant. First, of course, understand your contract, consult with the local attorney, and the local here becomes especially important because you need someone who understands the market that you're in and can speak eloquently to that. And of course, you want someone with specific expertise in physician contracting issues. You can bind your way out. Usually it's not too expensive. It might be $10,000, $12,000, something like that. And then if you can try to consider modifying the covenant, the blue penciling that I mentioned, whether that's through negotiations with the employer or when it comes to a point where you have to go before a judge and argue that it's unreasonable, therefore should not be enforced. Learn about restrictive covenants and these sorts of on future practice. Okay, I'm going to move on then. I'm going to talk about a couple of other considerations you really want to think about when you terminate the contract.
Keith, sorry, Keith. I had my phone on mute, so the callers didn't know all phone lines have been taken off mute. So if there's a question for Keith, please do so at this time. I do have one question for you, and that is I've heard of a situation here in our state, actually a couple of them, to be do that. And a physician had an agreement with an employer, changed the compensation model, and the physician had expressed some concern they had the restrictive covenant waived at them or kind of held over them. Have you heard of situations of that nature?
Unfortunately, it's one of those things where the employer may be making empty threats. The rule of thumb is basically, if the employer wants to change the compensation model and the employee doesn't agree, the original contract is still there. So if the employer does in fact change that compensation model without the employee's consent, that would be a reason for cause termination initiating the employee, in which case the restrictive covenant would not be enforceable. So I think, unfortunately, that's probably an empty threat. But for a physician with very little bargaining power, it's something that they don't, even if it's an empty threat, they don't want that over their heads.
Sure. I think, unfortunately, it's probably been used. So, okay, thank you for answering that. Any other questions for Keith at this time? Otherwise, proceed on. Okay, thank you.
About dispute resolution and how that works. So dispute resolution is important not just for the termination of the contract, but throughout all aspects of the contract whenever an issue may arise. And before I really get into specific mechanisms, I just want to note the importance of being sure to check it out with the employer, because often the two sides can come to an agreement, without having to go through any formal process. Employers are not looking to get rid of employees for the most part, because that costs them money. They don't want that. Nobody wants that. So I would encourage you, if you have an issue, to try to work it out with the employer, before pulling some sort of nuclear option. That said, if you do come across something where you're having trouble reaching consensus with the employer, there are options at your disposal. And they'll be outlined in the employment contract, what kind of mechanism is used in what situation. And I start with the most informal one, which is mediation. Basically, mediation just means you have someone who comes in, who's agreed by both parties, and tries to facilitate and get the parties talking and come to an agreement. But the mediator may even make a recommendation and say, well, based on what I've heard, this is what I would recommend. So the pro side of mediation, it's informal, it's quick, it's not expensive. On the con side, it's not binding on either of the parties. So the mediator may come to a great recommendation, but the party has to accept it. The next step, if you want to escalate things, would be an arbitration. Where both sides agree to have the case heard by an arbitrator, and it will be conducted under rules of the American Health Lawyers Association, or there are a couple of other arbitration. I think there's an American Arbitration Association or some such organization. They have very strict rules for how these arbitrators conduct hearings and come to decisions, etc. Basically, it's the employer and the employee saying that they're going to turn the case over to an arbitrator. They will abide by that arbitrator's decision, whatever it may be. So the pro side, again, it's less expensive than traditional courtroom litigation, and it's shorter duration. Con side, the arbitrator's decision is final, regardless, and the losing party is stuck with the decision, regardless of its fairness or its correctness. No rights to appeal. So you're very careful when you agree to arbitration, and recognize that you're actually waiving your rights to remedy situations through other mechanisms, including little remedies you may have otherwise. Now, escalating even beyond arbitration, you can go into traditional courtroom litigation. And the problem here is that the parties have maximum legal processes and rights to be heard, and they can do things, et cetera, et cetera. But it's very expensive, it's time-consuming, it's emotionally draining. In cases where physicians will leave an employer, and 5 years later, they're still trying to get something through the court systems. They've gone on with their lives, they've formed new practices, they're living well, and they've got this thing hanging over their heads from 5 years ago. Which dispute resolution mechanism is best. There are a couple of factors that are going to figure into that decision. The employer and the employee have to look at what is the magnitude of the damages. If you're talking about $15,000 or $20,000 in damages, do you really want to go to court for something like that, tie it up in a legal process? Just in legal fees alone could cost you 3 or 4 times what the damages are. You also have to consider what resources are available to the parties. If you're a physician employee and your employer is a hospital, the hospital is going to have tons and tons of resources. They're going to have attorneys. They're going to have all those resources to bring to bear against you as a physician. So the question, do you really want to engage in a protracted legal fight with them in the legal system? That might not be the best option. And then state law can also affect which dispute resolutions are allowed, which dispute resolution mechanisms are permitted in which kinds of situations. With negotiating a restrictive covenant, it's important to understand where the other side is coming from. And I'm not going to go into great detail about these negotiating mechanisms. Typically see is that the employer will tangle things up and make things as difficult as possible for the individual physician. And that comes usually simply to the fact that the employer has the resources to do that. On the other hand, the employee is going to try to get a quick, informal process that doesn't cost a lot of money and is likely to result in a decision relatively quickly. So mediation or maybe arbitration. talk about it, and I'm only going to touch on this briefly, is this notion of separation agreements, which you've heard of. So these go above and beyond the employment agreement, and what they typically do is they fill in any holes that may have been left when the agreement was originally written. They can be a fix also for insufficient or incorrect contractual language. Now, one of the downsides is that if it's not an amicable split between the employer and the employee, you're never going to be able to negotiate a separation agreement, so you're not even going to try. So this works much better if the employer and employee are agreeing to part ways, but they figure out exactly how to do that. You'll most commonly see this is in group practices, where contracts tend to be more informal. Sometimes they're not even written. Sometimes they're just verbal contracts. And you do this especially when the departing physician has an ownership stake in the group. And situations can get very complicated and interesting with they've got a practice that's a corporation and the physician shareholders, but then they're also employees of the corporation. Separation can get complicated on those kinds of issues. Separation agreement will outline all the things we've talked about tonight. It'll include components like the date of departure, what are the restrictions on future practice, non-compete, like that. Questions about access to patients and records, how exactly are funds going to be settled, things, confidentiality, non-disparagement, mutual releases, basically saying that you're not going to hold the other party liable for any damages you may incur. Could have stuff about dispute resolution, lots of things like that. Basically everything we've talked about tonight in one handy place. So guys, the things that we've gone over tonight, I want to reiterate that the ground for contract termination is really laid at the outset of the relationship when the contract is signed. And it's important to be thinking about ending the contract even as you're getting ready to sign it, because you need to ensure everything that needs to be in about the end of the contract is actually in there so that you have that smooth transition. As discussed, when the contract ends, the employer and employee still probably have obligations to one another, of course, the financial things, but also completing of various tasks. And then a recognition that terminating the employment contract does in fact have significant effects on your future practice. So terminating a contract is not something you should do lightly. You should consult the local attorney, and again, someone with specific expertise in physician contracting, do that before you terminate, and of course before you sign any employment agreement. Just as I'd like to make you aware of, I've mentioned these a couple of times and have cited some sample provisions from them, but the AA has these annotated model employment agreements. There's a hospital version and there's a group practice version. I particularly like the group practice version because it covers it from all these issues from the perspective of both the employer and the employee. See, what is the employer trying to negotiate? What is the employee trying to negotiate? And I think it really helps to understand where both sides are coming from. The AMA has principles for physician employment. That's sort of a general statements about what the AMA believes about the relationships between an employer and an employee. Passed on contract negotiation, that's the side. There are links between employment contracts and medical staff bylaws. It's in the hospital setting. So you may take a look at, the AMA has a guide to physician staff organization bylaws. Finally, if you do run into any of those medical staff / contract issues, there is a section AMA dedicated to these kind of issues. Information about all these resources can be found at that website there. It's just ama-assn.org/o/employment. I am finished. If anyone has any questions, I'm happy to try to answer them.
This is Mark. I'm going through and I'm unmuting all the phones, so if anybody does have questions for Keith, we'll check and hear your phone line should be open. I please encourage you to ask questions. I do believe all phone lines are open. Anybody has questions for Keith, please go ahead.
Hi, Mark. This is Steve Miller in Rapid City. My question is regarding termination, either cause or without cause. Looking at employer standpoint, I'm wondering why I not terminate an employee. Why wouldn't I always use without cause? Simpler.
Yeah, it is simpler. The problem is if you use without cause termination as an employer, then basically you're viewed for everything that happens in the future as the reason for that contract being terminated. So you could owe severance pay, or if covenant might not necessarily be enforceable against the employee. So there are some reasons that there are some incentives for a physician to use the for cause, but it can, again, the employer is going to weigh the costs and the benefits. And unfortunately, often what you'll see is, as I noted, that inappropriate use of without cause termination when there is a cause related to quality, and that's problematic.
Does that answer your question?
So I guess I'll just it once more. Not so much quality concern, but maybe a quantity concern. That somewhere without would be better used.
Probably, from the perspective of the employer, it probably would be, because if it's just a quantity issue, they probably just want to get rid of that physician and move on to the next person who can provide the volume that they're looking for. Yeah, I think you're probably right there. They probably wouldn't, you wouldn't see for cause if it's a quantity issue.
I hate to put you on the spot, but I'm assuming that there are more details that he may want to talk to you in specifically, not out of the whole group here, that you would be available or make yourself available to visit about that offline as well.
Yeah, so my contact information is there, and Mark, if you want to share that around, I'm happy to talk to anyone who has questions.
We can do that. Great. Any other questions for Keith this evening? Okay, but as we do know that sometimes folks don't always feel comfortable asking questions type of format. So as you see on your screen, Keith does have his phone number and email information. You are welcome to email me at the Medical Association meast@sdsm.org, and I will forward those on to Keith as well. One last call out. Any questions for Keith? None. I certainly want to thank you for taking your time to be with us. I truly learned a lot from this presentation. I think it gives us a lot of things to think about, and probably most often, or more often than not, it gives us things to think about before and into, agreements such as this, or reasons like I shared with you, that example of employer changing the terms of the contract and the employee being concerned about having a restrictive covenant held over their head. So I want to thank you for that. Please note that a copy of this presentation will be made available online at the Medical Association website, so www.sdsma.org. Further note, we are going to be working with the South Dakota Health Information Exchange to bring together a 4-part series on MACRA. The first program in that series is scheduled for Thursday, November 10th, 2016. Questions for Keith? I certainly want to thank you all for joining today, and I certainly want to thank Keith and his team at the AMA. They have been great working with us. We really appreciate all the time, energy, and resources they've given to us as we put together this this 5-program series. So, Keith, please thank you, and thank the team as well.
Very much for the opportunity.
So, if no parting thoughts, I certainly want to thank you all again for participating and wish you a good evening.